Always a good time to listen to your favorite show and mine. One More Good Idea with Marcus Newman.
Good morning, everybody. This is Marcus Newman, and we're here on One More Good Idea. I'm your host, and we're going to be getting started, jumping in the deep end this morning right away. So we are here to talk about a hot topic, and that topic is marijuana in the workplace. As many of you know, marijuana will soon be legal in the state of Illinois, and we are going to look at it from a relatively different angle. If you'd like to join today's conversation, our phone number is 773-763-9287. Again, that phone number is 773-763-9287. And here is what we're going to be talking about. We're going to be talking about marijuana and the workplace. Please call in. Please give us some comments on Facebook Live if you're watching. Join the conversation. But here's what I'm not looking for. I do not want to get into a debate as to whether or not marijuana should be legal. That is irrelevant for today's conversation. I don't want to get into a conversation as to whether or not you like smoking pot or you've waked and baked this morning is not of interest to me. But what we're talking about today is how employers and employees will function with each other as pertains to marijuana in the workplace. And in order to do that, I secured the services of a very professional, very respected, and a very experienced gentleman. His name is Bill Heffernan, and he's joining us on One More Good Idea today. Good morning, Bill.
Good morning, Marcus.
And welcome to our show.
Thank you.
It's nice to have you. Now, Bill, you are one of the owners of ERS, Employee Resource Systems, and ScreenSafe. Tell us a little bit about these businesses.
Okay, so ERS is an employee assistance program company, or members assistance. And so we get hired by unions and corporations to provide services to their employees. We do counseling. We help people find child care services, elder care services. Our job is to essentially help people in the workplace be more effective and be more productive by addressing and resolving their personal issues or personal challenges.
That part of your business, a lot of people will know it as the 800 number,
right,
that they can call and talk to, in your case, with ERS, a licensed clinical social worker.
Correct.
Right. Now, many employee assistance programs have people answering the phone who are not actually licensed
mental health professionals.
They're
right. Oftentimes just call takers and demographic collectors. And it's one of the differences between a lot of the big companies and ours is that we're a smaller company. We're more boutique-ish. And so we have a very hands-on approach.
And you are a Chicago-based business, correct?
We're right here in downtown Chicago.
Right. If you look out your window, I believe you could see a very tall, slender building with the president's name on it. Is that right?
That is correct.
Was such a view. Okay.
I keep those blinds closed.
So, Bill, you also own part of ScreenSafe,
right,
which is a company that does drug testing for employees. Is that right?
That's correct. About 20 years ago, I was working. ScreenSafe is an accidental company. We had a client that felt the need to implement a drug testing program. It was a trade union. The contractors and the union wanted to put in a program, a drug testing program. We spent literally 2 years negotiating that program and putting the pieces together because the union's approach was, we spend 4 to 5 years training these people to be qualified professionals, tradespeople. And so if someone does have a problem, if someone tests positive, we want to make sure they get the help they need to address the problem that they have and then get back to work. We don't want to kick them out. We don't want to turn them away. We want to figure out a way. So the way one of the union guys talked about it, it's a help and educate program. We want to help people. We want to educate them and let them make choices that fit for themselves and their families.
Okay, Bill Heffernan, I am satisfied that you are an expert in this area. So let's jump off the diving board. Before we do, let's give the number so we could get people to call in or comment on Facebook. We're talking about marijuana in the workplace, post-legalization. Our phone number is 773-763-9278, 773-763-9278, or hit us up on Facebook Live. And our producer, Nikos, how are you this morning?
Howdy, hey.
All right, I'm hoping that people will get engaged, but if they don't, Nikos, I hope you're back there taking notes.
Yep. Yeah.
Okay.
If you if you are on Facebook Live, you can go and share the post, and also if you have any questions or whatever, we can read your comments on the air too. So if you leave us a comment on the Facebook page, your comment may be read on the air.
Yeah, Nico said share the broadcast. Let's spread the word that ERS is commenting publicly and formally on this issue. Okay,
So
here we go.
can I just start by saying I want to be really clear. I'm not a prohibitionist. I'm not against marijuana. I just want to be really clear that this is something that my focus is on the workplace and workplace safety.
Right. I appreciate that. Bill is stating that he is not a prohibitionist, nor is he a pothead. He is here to talk about the workplace. And I would like to reiterate as well, I don't want to get into whether or not you like marijuana or what strain you like or what device you use to get high. I want to talk about the workplace as well. And I think people want and need to hear about this stuff. Okay, the law says that after January 1st, the recreational use of marijuana in your own private life will be legal in the state of Illinois. But there are many employers, I would say most, that have a policy, a drug-free workplace policy. So we need to understand how those two things will interact. First things first, straight up, if I drug test in order to get a job at my company, I want to hire, so I get applicants. I find the ones that I like the best, and I say, if you would like an offer, you'll have to take this drug test. They go and take a drug test. The only thing that comes up is marijuana after January 1st. Do I have to offer them the job, or can I tell them, no, thank you?
That's a really good question. And so there's a couple of levels to this. So if I'm a regulated entity, if I own a trucking company, or if I work in a space where there's Department of Transportation, Department of Energy, Nuclear Regulatory Commission, it's very clear that, yes, you can have a prohibition against someone testing policy or positive, because the federal regulations require that you do drug testing and people have a zero level. It gets more complicated because the way the Illinois law was written is that you have privacy rights. And the Illinois law, the marijuana law, was written in such a fashion that it incorporated the Illinois Privacy Act. So that if I use a substance off of work that is legal, if I smoke, my employer can't prevent me from smoking cigarettes because I'm doing something that's legal. So they can't not hire me because of that. So the way the law was written is it protects people from having their employment encumbered in any way because of their use of a legal product off company hours or off company premises.
Okay, so let's call this law on its surface pro-cannabis.
I would say that's accurate.
Okay. Now, you said a couple things, and I just want to make sure that we cover them so that everybody is clear and following our conversation. Marijuana, while legal after January 1st in the state of Illinois and 11 other states in the country, is still illegal federally. And therefore, if your business has federal contracts, is regulated by the federal government, is funded by the federal government, has a relationship with the federal government, then you as an employer still have the right to 100% drug-free workplace. And if somebody tests either on their way in or while employed and shows that they have the THC chemical in their bloodstream, meaning that they have used cannabis, you are able to release them from employment.
I believe that's correct. I think we're going to still see some testing of that around the 80s law about the drug-free workplace that doesn't specifically require testing. We'll see some legal court challenges around whether or not, as an example, a healthcare organization gets federal dollars under the 80s, under the 80s law related to having a drug-free workplace. They need to have a drug-free workplace.
Okay.
So I'm not sure, and this is going to be one of the many tests that occur, whether or not that will extend to folks who test positive for marijuana come January.
I would imagine that this law will be tested in many ways and very quickly. Okay, Bill Heffernan from ERS and ScreenSafe. This is a historic moment because we have our very first caller. I don't know if it's the topic or, Bill, if it's your expertise and acumen. However, we do have our first caller. Nikos, tell us who's on the line.
Maria is calling about marijuana and federal employees.
Maria is calling about marijuana and federal employers. Maria, welcome to One More Good Idea. I'm Marcus Newman, your host. Thank you so much for calling in. What's on your mind?
Hi, thank you. I've been listening to your programs. This is the first time I've called in. And what I want to say as a federal employee, we're banned from, being on the influence of any drug. We could lose our jobs. And if you're tested positive, that's not going to work because federal law trumps state law. So, and federal employees are aware of this.
Yes.
So,
Okay. So, Maria, a couple of things. First of all, I want to thank you for calling in. The idea that someone is out there listening to this show really blows my mind, and I appreciate you very much. Secondly, I would like to say that I enjoyed your use of federal law trumping state law. I thought that was a nice way to say that based on our current Oval Office occupancy. And second is I believe, I understand that you are right. So I understand that if you're a federal employee and you drop dirty in any way, right, whether it's cannabis or any other substance, that you will be released from your employment as a result of that. That's your understanding as well. And you're saying that everybody that works in a federal position knows that?
Looks like she's gone.
Yeah. Okay, great. So Maria, thank you for sharing that with us. Yes, we understand that. We do. Now, Bill, let's talk about non-federal employees. The majority of the people that work for small businesses and medium-sized businesses in the state of Illinois, they do not work in federally, regulated industry. So I'm an employer. I've got a drug-free policy right now. You're telling me that based on your reading of the law, after January 1st, my drug-free policy does not apply to cannabis because of the Privacy Act from the 80s. And this has to do with a couple of things. So in preparation for this show, I read a few articles and I came across this concept of this scientific and accepted level of impairment. So I'm going to ask the question and frame it with alcohol first, and we'll go to marijuana. I know in the state of Illinois that if I am operating a motor vehicle or if I'm at work or whatever, and there's a situation and I have to, and there's a suspicion of my alcohol use, I will be given a breathalyzer test.
Right.
I will have to blow into a tube that's connected to a small machine, and it will give a digital reading of my blood alcohol level. And this is the level of the percentage of alcohol in my blood based on the scientific methodology of analyzing it through my breath.
Correct.
And I know that if there is 0.08, so 0.8% of my blood shows alcohol based on this test, that I am impaired.
Well, let me just put a finer point on that. If I'm regulated, if my blood alcohol level is 0.02 or above, then I am not able to work if I'm in a regulated position. If my blood alcohol level is 0.04 or above, that's considered a violation of policy. So 0.02 to 0.04, I can't work. 0.04 or above, it's a violation of policy, and I have to be referred for an evaluation and follow whatever steps are recommended through that evaluation. 0.08 is the level for a DUI for a driver. And so it's a much higher standard than a regulated standard. So if I'm a CDL a truck driver, I'm held to a much higher standard in terms of 0.02 or 0.04.
Gotcha. Now, you said I have to be referred. Who's mandating that referral?
It would be the regulatory agency. So if I'm a truck driver, over-the-road driver, and I test at 0.04 or above, I have to go to see a substance abuse professional, be evaluated. Essentially, I have no privacy rights. So if I'm a truck driver, I test positive, I get sent for an evaluation. The evaluation happens, the evaluator reports back to has a set of procedures they have to follow, and then I have to do whatever they recommend, and I get returned to work once I've cleared whatever requirements they've set forth.
Understand. So there's a protocol for regulated environments. Let's talk about non-regulated environments. Let's talk about the office situation where people are just, Dunder Mifflin. Moving paper. So what sets the standard in a non-regulated? Is it the policy of the company?
It's the policy of the company, absolutely.
Okay.
And so the company can determine, hey, do we want to do this? Do we want to test for that? Do we not want to test for that?
And what drives that, do you think? Is it the employer or the manager's vision or their experience with that employee? They see them and they think, this guy is a little drunk or whatever the case may be, and then that initiates it, or is there another mechanism other than just that?
Well, I think that's what drives the decision to do, as an example, a for-cause test. But let me just step back and say, I've been doing this for long enough to recognize the fact that in 88, 89, and 90, when these rules and these policies and these programs began, it was really in many ways driven by workers' comp issues. Because there were so many injuries, there were so many accidents, there were so many issues in the workplace related to people coming to work impaired or high or affected by drugs and or alcohol, companies wanted to figure out a way to insulate themselves from the risk of workers' comp. And so some of these programs were built around that notion. And a lot of the carriers, the workers' comp carriers, will give employers discounts for having drug-free workplace policies and programs. It is yet to be, it's not clear to me yet how that's going to play out.
Yeah, so what we do know is at the end of President Barack Obama's administration, there were changes to this law in regard to testing people post-accident relative to drugs or alcohol, because there were, as you expressed to me in our pre-show preparation, there was concern about people not reporting for fear of repercussions regarding alcohol and or other drugs.
Right. So the OSHA rules changed. It had been that if I had an accident at work, my company could have a policy that said, if I have an accident at work, I can automatically be tested. Now, the Illinois law sets that out. You can still do post-accident testing. But under the OSHA rules that were changed prior to Obama's leaving office, there had to be cause, because, as you said, a lot of folks were concerned that if I got hurt at work and I knew I was going to test positive, I wouldn't go to the doctor, I wouldn't go to the clinic, I wouldn't get treated for my workplace injury because I was afraid I was going to test positive. So that rule changed. I'm not sure where it's at now.
Gotcha.
But
I'm sure it's changed and it will change again.
Yeah, I mean, a lot of the things that were done towards the end of the Obama administration have changed back already.
Yeah,
particularly with regard to environmental protections, but separate topic.
Yeah, that's a different show. We'll have you back. So, okay, I want to return to this scientific standard of impairment, which we have for alcohol. There's been tons of studies. You could go to any high school, and in the driving class, they have those goggles, and they put them on the kids' faces, and say, this is what your vision is like when you're .04, and we have all of this material, but we do not have a scientific standard of impairment as pertains to marijuana. Is that true, as you know?
That's correct. Right. I mean,
and is that, just to say why we don't have that, is that because marijuana has been illegal and the scientific research just hasn't been done yet?
Well, if you read the articles or all the different things about marijuana that are center, not left or not right, but they're center, just, here's facts, here's information. What you keep reading over and over again is there's not sufficient research. There's not sufficient research. We need more research. And part of what's happened is we've had this prohibition on doing research with marijuana for 70 years, essentially. And we've had the drug warriors, the Jeff Sessions, and those kinds of people who have said, we can't do this research because we don't want to know about this, which has really, in many ways, crippled us. So when the DOT regulations, the NRC regulations came out in the late 80s, early 90s, as an example, the cutoff level for marijuana on a screening test was 50 nanograms per milliliter. I believe maybe it was 100 nanograms. I'm not positive, forgive me. But the cutoff level was set at, I believe, 50 nanograms. And then over time, what they did was they lowered it to 25 nanograms per milliliter as the cutoff. And then it was confirmed using a more accurate testing methodology. And so when the tests first came out, even then, they were using this arbitrary number of 50 nanograms and then lowering it to 25 nanograms. And what they found was so many more people tested positive when they lowered it from 50 to 25. Now, the confirmation is using a different technology, and the cutoff level is 15 nanograms per milliliter, which is pretty low.
Yeah.
So, it's evolved, but currently there is no good way to discern whether or not someone's impaired from their use of marijuana.
Right. So we know that when you're looking at nanograms per milliliter, whether it's 15, 50, 100, you're just looking for presence. You're not judging impairment. And this is one of those things that that I think is going to become so critically important, and an opportunity for some scientific company to create a system that judges this. I'm going to draw upon a different part of your experience. I happen to have known you for a long time, and I know your expertise. And you work in, besides just ERS and ScreenSafe, which is enough for any human being, you also have a tremendous wealth of history in drug and alcohol counseling as part of the ERS and other things. I'm going to ask you flat out, in your opinion, as an expert in the field, does marijuana use impair someone's ability to do their job?
Oh, absolutely. I mean, in so many ways, it impairs people's ability to do their work. If they're high at work, their timing is off, their visual capacities are off in terms of depth perception. There are a number of subtle impairments that occur. And one of the things that concerns me is that if I'm not actively high, if I don't look high, but I'm a little under the influence, it has an impact on my ability to perform my duties safely and effectively. I think in Colorado, they saw the number of car accidents related to marijuana impairment go up by 30% when they introduced legalized marijuana. And I'm not, again, I don't want to be a fearmonger. I just want us to be really thoughtful.
I understand. And right now, all my friends who are marijuana users are freaking out right now and saying, well, what about my friend who was the valedictorian of high school and he smoked pot every day? How do you account for that? How do you account for that?
I mean, I know, because of my work, I know a lot of people who are active alcoholics. I remember doing training at one client at one point in time and somebody coming up to me and saying, the guy who runs my work is an active alcoholic, but he's still really good at his job. And so, I'm not going to do anything about that. I work in a financial services firm where one of the senior people had a drinking problem. Everyone knew he had a drinking problem, but he brought in so much business, there was no way they were going to deal with him.
So impairment is relative, and policy is going to prevail. Okay, we're so close to being out of time. Bill, this can go on forever. I'm going to ask you publicly in front of everybody to have you back on the show again to continue this conversation. I think it's an important one, and I don't want anybody to think neither one of us, I think, are against marijuana. We have one more call. I want to take it before we wrap up. Nikos, who do we have on the line?
Are we talking to Tommy? He's like my Herb in the workplace.
Tommy. Hey, Tommy, we're talking about you work with a guy named Herb. Is that right?
Yes, right. I've been involved in it probably the last 50 years. But it's interesting when they regulate something like that. How in the heck do you determine with the different strains? That's why they have an increase in the accidents,
Right. Tommy, Tommy, let me say a couple things. First of all, thank you so much for calling in. Tommy, I did this show because I know it's a hot topic and I know it's important to people. It's important to me. I believe, Tommy, that the scientific research that is going to explode as a result of the legalization of marijuana, testing and levels of impairment and coming to some consensus like we've done with alcohol is in our near future. And I think that is the greatest opportunity, maybe even a greater opportunity than the guys who are carrying the licenses to sell the weed, which I know people want to buy and they want to use. And they definitely want to sell it, clearly. But I think that these kinds of measuring elements are going to become prominent. They're going to be able to measure this stuff like they're able to measure blood and alcohol. What do you think?
Wow, that's interesting. I was just going to say it should be interesting how they do that. But at the end of the day, it's probably they've already done all the studies. I remember, right?
Yeah, well, there are some, but they're not complete. They're not as in depth as they need to be for all of us to agree. Listen, I've got to wrap up this segment. I just want to thank you again for calling in. The idea that you're out there listening to the show makes me so happy. I don't even know how to express it. I hope you'll keep tuning in and calling in and being a part of our community. Thank you so much for the call.
Marcus, can I say one last thing about
Please.
the Illinois law? I mean, the thing that concerns me the most, because I've worked in corporate settings for the last 30 years, the thing that concerns me most about the way the law was written is it puts the burden of determining whether someone's impaired or sufficiently impaired that you as a supervisor want to take action to send them for a test. The law is very clear about the burden is on the employer to assess whether or not the person's impaired, can or cannot do his or her job safely and effectively. What I know is that supervisors loathe to take this action. They're not good at it. They're uncomfortable with it. And so, I actually had one nurse manager once at one of the organizations I work with say to me, I know one of my nurses is smells a little bit drunk, but she's really a good nurse. And so she didn't deal with the impairment for years because she didn't want to have to deal with it.
Yeah, well, people are not good at confrontation, and you know that, and this is going to force managers to confront more. Bill Heffernan from ERS and ScreenSafe, I appreciate you so very much. Thank you for helping us get this topic started. We obviously need more time, and we obviously have a lot more to talk about. But if you're an employer and you need help addressing this issue, which you do, you need to address this issue. And if you wait till New Year's or Christmas, it's going to be late and trouble is around the corner. Reach out to ERS, Employee Resource Systems. They're online at ers-eap.com, or you can find them. You could call the show. You can look them up online. You can do a Google search for Bill Heffernan. You'll find out that he and his business partner Gary Cohn are amazing in their field. Thank you for joining us on One More Good Idea. We'll have you back to talk more pot in the future.
All right. Look forward to it.
Thank you, Bill.
All right.
All right, Nikos, take us out.